hearing in the appeal of the criminal notification of Section 6 of the Home Department.
Hello, my lady, good morning. Could I ask you first, please, to take up the black ring binder which is on your side tables. That's the product of some work we've been doing overnight to pick up some sweep-up points from yesterday, if we may. I'm conscious of the time, so I hope I can take them relatively quickly. The first sweep-up point was in relation to a matter I think Lord Clark raised, which is whether or not it was appropriate to take into account the application of the notification regime on sentencing. There is an authority in tab 11 of this bundle, an Attorney General's reference, which indicates that to take into account the application of the consequential notification regime as part of the sentence is wrong in principle. It's the Court of Appeal Authority, tab 11, and you'll see the holding in the head note, and the relevant parts of the judgment are on the second page. If you turn over the page, on the back of the page, it's the final two paragraphs on that page beginning as to the effect of the 1997 Act and so on, summarising the submissions made on behalf of the offender, and then the dispositive paragraph is the final one on that page, starting in our judgment.
Yes. Yeah.
I think my learned friend, Mr. Southey, has handed up some other materials. I think within those, we don't need to go to them perhaps, but just for your note, we note it perhaps next door to that paragraph. I think in them is the judgment of Lord Justice Latham on the CCRC reference in this case, disposed of in January 2009, and the same point is made by reference to this authority in paragraph 15 of that judgment. So the side note beside this paragraph is paragraph 15 of Latham LJ judgment on the CCRC reference. Second sweep-up point, the question was raised, hopefully, as to whether or not our case accurately summarised the legislative provisions insofar as they apply to England, Wales and Northern Ireland. We've checked back and our case does accurately summarise that, so that's a blessing at least. But the position remains that the most accurate way of assessing the English versus the Scottish provisions is in tab 69.
Yes.
Because that's the only place where the distinctions properly appear. We've checked back into OPSI, and OPSI also has its own difficulties. So I'm afraid it's tab 69 is the authoritative place for the legislation. I referred yesterday to the provisions regulating the manner in which the order-making power was to be exercised, the affirmative resolution procedure being prescribed for sections 83 to 86 regulations or powers. Section 138 is in tab 8 of this black bundle. And that's just simply for completeness. One doesn't perhaps need to turn it up, but it's there if you want it. But we've also produced in this bundle better copies, both of the Jenny Can article, which was at pages 202 to 210 of the appendix. That is at tab 9 of this bundle. And so, I don't know if that's...
Sorry, I'm just looking at the astonishing difference between them.
It's astonishing, yes.
Well, that's the that's
Professor
the
Thomas's article.
Yes, this is not well, there is an astonishing difference. I'm glad. Yes. So I hope that's helpful as well. The Thomas article is the next one. So there are better copies of there. In relation to the question, do we have any information as to effectiveness, who's gone missing and so on, under the regime, the best we've been able to come up with are some figures as to the numbers of people who have been charged or cautioned for breaches of the notification requirements. We've got some annual figures in relation to that, which span the period 2005/6 through to 2008/9. Very broadly, the figures of charges and or cautions for breaches are in the region of 1,500 a year. The actual figures go 1,286, the next year it's 1,552, the next year it's 1,634, the one after that it's 1,337. But the broad figure is roughly 1,500 a year charged or cautioned for breaches of those requirements. The Supreme Court of Canada case, we're very grateful to Mr. Mambro for sending an email notifying us. We got there almost exactly the same time.
Sorry.
Don't worry, it's very helpful to have it just in case we were on the wrong track. I certainly started off on the wrong track with a case called Macintosh, which responded equally to an absurdity word search, but related to a rather different point about whether or not you could rely upon that for the purpose of getting out of clear words of legislation, to which the answer was no. But the relevant authority is Galt's, the Queen and Galt's. That is at tab 7 of this black bundle. It related to challenges to automatic penalties prescribed by Canadian legislation for driving when banned. You automatically went to prison for 7 days. The previous authority, which is relied on in Galt's, was a case called Smith, where precisely the same point had been raised under Article 12 of the Constitution. Was that a cruel and unusual punishment? If it was it, as it were, an acceptable balance under Section 1 of the Constitution?
It wasn't a driving offence. Smith was
to do with drug importation.
Exactly.
And that was a rather starker example, perhaps, because the relevant legislation prescribed a minimum sentence of 7 years of imprisonment for importation of drugs, but drew no distinction between, on the one hand, the person who imported a lorry load of cocaine or heroin, and on the other hand, the person who was stopped as a first offence with a single, as it was expressed in the judgment, joint of marijuana in his car, who also got 7 years by the same token of the legislation. The relevance, I don't think one needs to go into the facts of Galt's unless one needs, my lady would wish to. The relevant statement of principle, and it flowed from the nature of the analysis that had been set up under the Constitution by the Canadian authorities, is at page 37 of the authorities, at the bottom of the page. In brief summary, the analysis prescribed by the authorities in Canada set up a two-stage test. First of all, one looked at the individual circumstances of the particular case in order to judge whether it was cruel and unusual, and then, even if it passed muster, as it were, on the facts of the individual case, there was still a broader inquiry to be conducted, which was whether or not one could envisage other situations in which it might apply in a grossly or manifestly excessive manner, and it was for that purpose that this principle was set out. But the relevant principle starts with a reasonable hypothetical example, last bit on page 37, and perhaps goes over to the end of the first paragraph on the next page, ending with day-to-day life. Well, that's the Canadian authorities. My Lord Phillips asked in relation to what the test was where, for release of a sex offender if they were given an IPP. That is dealt with in tab 12 of this bundle, where the relevant legislative provision is set out. I think the test is whether the parole board is satisfied that it is no longer necessary for the protection of the public that the prisoner should be confined, and the relevant sections are 28(5) and 6 of the Crime Sentences Act 1997. It's perhaps to be noted that the IPP is categorised as a life sentence, see section 34(2). So I hope that assists on that point. More generally on, and perhaps more significantly in terms of the submissions I was making yesterday, I referred on a number of occasions to the existence alongside this regime of the retention of information on the PNC of conviction information. And we've sought in tab 1 to this note to set out the relevant governing provisions that would apply to that sort of information. It makes reference, as you will see in the final paragraph, to an authority that is in the bundle. Do we have a tab for that? Which is the Court of Appeal's decision in the Chief Constable of Humberside Police and the Information Commissioner. That's at tab 37 of Authorities Bundle 4. that we've set out the relevant legislative regime which governs retention of that information, and I hope that all the legislative pieces referred to in that, and indeed the ACPO guidance, are in the following tabs, so from tabs 2 to tab 6, so you've got a bounce reference if you want into the underlying legislative provisions. The long and the short of that note is to indicate that for sentences of this kind, the likelihood is that conviction information would be kept for the lifetime of the offender. My lords, my lady, Wilson and First County Trust and the question of Hansard. If I may, I would like very briefly to go back to that. It's in Authorities Volume 2, tab 14. I think we picked up the most relevant paragraphs yesterday, although we would perhaps invite you, if you're going back to that authority, to read rather more extensively in the speech of Lord Nichols. The relevant paragraphs run, in fact, from paragraph 51 through to the end of paragraph 67. 66 and 67 are the most relevant, plainly, but it is of assistance in my submission to read the entirety of that shortish section, and it is also of assistance in terms of the application of the principles, how the dividing line that was drawn by your lordships in that case, how it was actually applied, is of some assistance, and we would also therefore invite you to read the dispositive section so far as that point is concerned, paragraph 68 and following, in particular paragraph 71, 72, 74, and the reason for concluding that the Court of Appeal adopted an erroneous approach, 79. My Lord Hope helpfully reminded us that he also dealt with the issues, and we would also invite you to read the section of his speech which deals with that point, in particular paragraphs 115, setting out the rather broader proposition for which Mr. and then the dispositive paragraphs 117 and 118. The principles that we derive from those paragraphs.
There is also paragraph 144 in Lord Hobhouse.
My Lord, yes.
Yes.
Yes. I'm sorry, I should have drawn attention to that too, certainly. To the same effect.
Yes, exactly.
The principles that we derive very briefly from that authority, if I may, are firstly that it is legitimate for the courts to have regard to Hansard in the proportionality context by way of background and by way of illustration of the mischief or purpose of the legislation. However, secondly, the courts should be cautious not to stray over the constitutional line into territory where they are in effect questioning proceedings in Parliament. And that line will be crossed, as it was in the House's judgment by the Court of Appeal, if one ends up in judgments, as it were, questioning the validity or the efficacy of reasoning given by ministers for the bill in Parliament. So, for example, statements that were made in the Court of Appeal judgment in that case where the reasoning appears to us to confuse matters of that kind would stray over the line, both for a Bill of Rights reasons, if I can put it that way, Section 9, but also for the reason which has been referred to on a number of different bills,
in this kind of area, you would expect there to be a lot of background material which had led to the very specific scheme that was put before Parliament. And plainly, it's desirable that one should have regard to that data. Parliament would be considering the same question that the court has to consider. And it's a very delicate line that has to be drawn between explaining why one's reached a different decision or conclusion to that expressed in Parliament, with actually criticising the conclusions expressed in Parliament.
And it is a line which is difficult to apply in individual cases, which is why, in particular, I was inviting the court to read the dispositive section of Lord Nichols' speech, because it gives one an indication as to how the court broadly expressed principles should be applied in practice. The third thing to bear in mind in relation to the principles emphasised in this authority is that the test is a current one. It does not reduce the value of Hansard. The question is whether it is proportionate now. And so the more relevant information and evidence is the evidence that is currently before the court of later challenge. It is of less importance. It may still be important if there's been no material change to the way pass over that. But the challenge is a current one. Fourthly, however, on any view in the submission, it is relevant for the court in assessing the margin of appreciation of the area of judicial discretion, the respect to be accorded to Parliament's judgment. It is on any view relevant and permissible to take into account the fact that a particular amendment was considered by Parliament and not proceeded. No view do you stray into questioning proceedings in Parliament or calling into question the judgments that might be made. No constitutional limitations with that. And it does indicate that Parliament, for whatever reason, perhaps doesn't need to explore the reasons, for whatever reason, did consider the very option. So, for example, here, as I drew attention to yesterday, the fact is, as we know, that an amendment was put down, the effect of which would have been to introduce, in alternative forms, as it turns out, would have been to introduce some form of review or appeal after the notification requirements had cut in. And that was not proceeded with by Parliament and didn't feature on the face of the bill. And for our purpose, in terms of Hansard references, recognising that it's a relatively fuzzy line.
Parliament didn't make a decision about that, did it? It was withdrawn.
Well, it was not proceeded with.
So Parliament didn't make a decision about it.
Well, other than that Parliament could have insisted on a right of review if it had wanted to. And the bill that did go forward to Parliament and became the Act did not contain a right of review. And we touched yesterday on whether one could, as it were, construe indefinite to import some form of review, and our submission was to be Parliament.
I think Jackson supports the proposition that one can have regard to amendments that have been debated and then withdrawn or lost in the House.
I mean, it's a relatively new doctrine, that, because I can remember arguing a case where Lord Mustall was absolutely clear it simply couldn't be done. So, I mean, but now we've moved on to that stage.
And also for that purpose, there are some...
So if there were material, if suppose we were lucky enough to have the material that Parliament had, which we haven't been, but suppose we were, would that be relevant material for us to consider in deciding what the position is now on proportionality?
My lord, if you had, for example, the consultation...
Yes, I suppose we had all the consultation and we were able to look at it, we were able to see what consideration was given to these questions, how much thought there was, what the arguments were on either side and so on. Suppose we had all that. Would it be relevant material for us to consider in answering the question which has to be decided as at today?
I would respectfully draw a distinction between the types of material. There's never been a difficulty with access to or taking into account consultation papers and matters.
So the answer to my question is yes.
The answer in relation to that category of material is yes, and we have the consultation paper that preceded the 1997 Act if you want it, but plainly it's got to contain material going to the issue that you're considering. And I've had a look at the consultation paper and it doesn't seem to me it takes matters a great deal further. Frankly, it poses the question, should we cast it in this form or the other form? It raises the issue rather than setting out, as it were, a great evidentiary material I would accept is relevant and can properly be taken into account. More complicated are references to Hansard and what material was advanced by ministers in support of or in opposition to a particular amendment or proposal. Then one does get into the sort of territory that was actively considered in Wilson.
It's really the third last sentence in paragraph 79 may be the key to this. This is the top of page 847 in Wilson, where he sums it up in that sentence. The court should simply have regard to the relevant statutory provision, that's one thing, and its policy objective, and it's in trying to understand the policy objective that one looks more widely, I suppose, at other material, and then consider whether the provision, as bears so unfairly and so on, it wasn't open to Parliament to do what it did. I mean, you've referred to us to that paragraph, I think, because you accept fairly obviously what Lord Nichols says there, but
yes,
that really encapsulates the point, doesn't it, in the end of the day?
It does.
It's odd, isn't it, to formulate it as it was not open to, if we're deciding it today. So I respectfully doubt whether that can really be quite correct. Great respect for Lord Nichols. Or at least he can't quite have meant it, because the whole essence of his decision was that the court makes the decision on today's material. The question isn't what was open to Parliament at the time. The question is what is proportionate now. And those are different questions. I quite follow that there is an element of deference to Parliament and so on. All those are very important questions. But as formulated, with great respect to Lord Nichols, I think it's questionable.
Well, it may be that the explanation for that, in defence of Lord Nichols,
That's right.
is to be found in the final sentence in paragraph 62, which is that at least on the fact of that case, there didn't appear
Not too much
to him
change.
to be any difference as between the date on which Parliament enacted it and the date on which the court considered it. So I'm entirely content to accept my lord's right on the more.
But then we're back to what Parliament was considering.
Then we're back to what
I
Parliament
mean, when you say change, I mean, if they weren't considering the details of this, is there a change, isn't there a change? I don't know, it's very odd.
Well, the other reason for
Why don't we just look at the question today and decide today whether it's proportionate?
I do use the present tense. I can't claim to have thought it through as fully as Lord Clark's suggesting, but in paragraph 18, just below letter F, the question is the legislation compatible with convention rights, which is our question.
We're all agreeing on that.
But I respectfully suggest that that is a different question from the question posed in paragraph 79, which is, was it open to Parliament?
Yeah.
Those are different questions, both conceptually and in substance.
Yeah. Lord Hobhouse at 144 makes the same. He says that it's probably academic in most cases.
Yes.
The principle that you can't question what goes on in the House is absolutely fine when you couldn't question the end product. The minute you change the Constitution so that it's the duty of the court to consider the compatibility of legislation, it makes it very difficult. If you can't look at what was said in Parliament to assist in that. Imagine the minister says, now the reason we're taking 30 months is because statistics clearly indicate that anyone who's sentenced is 30 months or more, A, B, C, and D. Now, does one not have regard to that statement? And then there's the justification that's been put forward, and then the court has to consider whether that justification holds good.
Well, my lord, the difficulty I think with that, which is a difficulty, which is addressed in the broader reading of Lord Nichols' speech, is that there is still a line. It is complicated by the fact that the court is now directed to the substance of the legislation. One isn't simply dealing with interpretation. Move beyond pepper and heart, and to some extent, Parliament has itself decided that the courts should be engaging in that exercise. But there is nevertheless, as Wilson makes clear, there is nevertheless a line to be drawn somewhere. The question, therefore, is where and how, and by reference to what materials does one go about doing that?
It was an absolutely critical issue because that's why Mr. Thompson was in the case. I mean, he came in on behalf of the Speaker and the Clerk of Parliament. I mean, that was absolutely what it was all about. I mean,
But the reason I invited you to look rather more broadly into Lord Nichols' speech is because he does address precisely where that line is to be drawn. And although it remains to some extent fuzzy on the edges, there is some clarity, as it were, on the extremes either side. So consultation papers, all the matters that could properly have been taken into account beforehand for the propriety of pepper and heart and interpretation, all still fine. Particularly important perhaps in this context is paragraph 67, where he is addressing the House and emphasises that the judgment of what Parliament intended and how it, and the proportionality analysis and what the will of Parliament was and so on, what its justifications were for the course it took, is first and primarily to be found in the wording of the Act itself and in obvious inferences to be drawn from it.
Can I just ask a sort of idiot question, really? My impression is that when the Human Rights Act first arrived, and partly because so many of the cases were taken by judicial review, there was a tendency which manifested itself in the Denby High School case to apply the principles of judicial review. Why did the particular body whose decision was being questioned as incompatible with the convention rights reach that decision? What were the reasons they gave at the time, and were they good enough? Yeah. Because that's the cardinal judicial review approach. You look at the reasons that were given at the time and you ask whether they amounted to a good enough approach. And it took really quite a long time, including Denby High School getting to the House of Lords and various other cases, before that approach was finally knocked on the head. Now, my impression of Wilson and First County Trust is that the Court of Appeal had actually applied that approach to the reasoning given in Parliament for passing a piece of legislation in 1974. And that was really what the problem was. And all of this is really trying to say, well, that's obviously not what you do. You obviously look at the situation now and ask whether the outcome of this legislation is or is not incompatible with the convention rights which we now have and didn't have in 1974. And I think it's as simple as that.
You may well be right that that's the inference and that's the drift, as it were. But we have now arrived at the point where everyone accepts that at its heart, the proportionality analysis requires an objective analysis. Yeah. Does the effect of the legislation give rise to disproportionality?
Yes,
absolutely. And anything that Parliament knew that helps us to decide what the objective was and how the two things link together is helpful. But it doesn't necessarily answer the question.
It doesn't necessarily answer the question because one still gets into, unless you accept the broader propositions which Mr. Thompson was contending in this case, you still have to recognise that a line is to be drawn somewhere and the question is where.
But the line, surely, is drawn, as can be seen in the sentence in paragraph 67, to which we refer. The court is called upon to evaluate the proportionality of the legislation, not the adequacy of the minister's exploration of the policy options or of his explanations to Parliament. That's where the line is. Absolutely. And as long as you don't look and see what the minister was saying or any of that, then all the underlying material is available, as the common sense suggests it should be, to decide what is proportional now. That seems to me to be the simple position.
Mr. Thompson's submission was, as we can see at page 823, you don't use pepper and heart to see whether Parliament has a good enough reason for what it did. I mean, that was his basic point.
To which I would accept that.
So this is really a pepper and heart type case, really. It's not a what's relevant to proportionality type case.
The only thing I would perhaps add to that sentence is that it should be read in the context of what has preceded it, particularly F and G on that page, which is at the starting point, and it ties in very closely with the objective nature of the analysis at the starting point. What Parliament has actually done. What are the effects created by the clear words? And so, for example, when
well, obviously, because this issue of proportionality doesn't rise until you've decided what the statute means.
Well, quite. But
you don't get to incompatibility until you've construed the statute and you've read it down as far as you can. You only get to the question of whether there's incompatibility once you've done all that. So all those are relevant to the question of what the statute means. But when it comes to proportionality, you're looking at today's position on today's evidence. But what you can't do is what Lord Nichols says you can't do there.
And when you come to work out how Lord Nichols then chose to apply in the particular circumstances of that case, those principles that you've identified does provide some elucidation. And it does because the relevant provision in that case that was in question was 1274 of the Consumer Credit Act. And the question was, why did it impose mandatorily in all cases a particular outcome, i.e. unenforceability of the contract, rather than leaving it to the court to determine in each individual case whether justice and equality fair. And when it comes to see how he applied those principles, it is revealing. He doesn't go back to Hansard, he doesn't go back to any of the pre-act materials. He simply says, here is the act. It's evident on the face of the act that Parliament advisedly and deliberately drew distinctions between, on the one hand, a category of case which should lead to the consequence that the court is master of the discretionary judgment, and those cases where Parliament itself chose to prescribe the consequence of the matter set out in the legislation. So he didn't feel the need, contrast the Court of Appeal's approach, he didn't see the need at all to go into any of the underlying material, consultation papers, Hansard, what ministers said or anything. He started in his analysis of how the case should be disposed of with what he described as the cardinal constitutional principle in paragraph 67, which is to look at the nature of the legislation and then work out its effect. And then said, well, it's evident on the face of it that Parliament is painting with a broad brush and has done it this way rather than the other way.
Yeah. Yes. We're not really into interpretation here at all, but I wouldn't, I think, concur with Lord Clark, because it seems to me that when you're interpreting, you try to interpret in a way that is going to produce a proportionate result. So you can't really do it in two separate stages.
My Lord, it's perhaps a complicated issue and a difficult line to draw, which is why it may be, if my Lords and my Lady go back to this case, it is worth in my submission seeing not merely how he expressed in the rest of the Lordships expressed the principles, but also to see how he applied them.
We're being too
in the
discursive.
I'm sorry.
Careful.
That was Wilson. I'm sorry, back to Bouchacourt.
Yes.
And that's at tab 6.
Volume 6.
Volume 6, tab 55. I'm sure we will all have had the opportunity to read the relevant bits of Bouchacourt now. So in the interest of time, maybe it's worth my summarising what we say about it. The first thing we say about it is that it's very important to bear in mind in my session the nature of the review process that was in issue in that case. I took you yesterday to the setting out of the relevant reviewing provision.
So which volume is it? I'm sorry.
I'm sorry, tab 55 in volume 6.
Thank you. Carry on. I've lost it for the moment. Go. Here it is. Yes. Thank you. Yes.
Our understanding, at least, is that what was in issue in that case, hence the citation of all those relevant articles from the Code of Criminal Procedure that begin in paragraph 16 of the Court judgment, was a composite system. So the Court was considering the regime which governed the entirety of both the conviction information, the record of the conviction, so our equivalent of PNC and so on, and also what I described as the wraparound information, name, address, current address, updating, and so on. One sees that from the descriptions of the relevant articles in the judgment. And the particular right of review, therefore, is Article 706.53.10, which is about four pages in, two-thirds of the way up the page. 706.53.10, which I took you to yesterday. And that permits an individual to challenge the totality of that information. In other words, including the continuing record of his conviction. Now, what I'm afraid I don't know, and seems at least relatively unclear from the second paragraph under that heading, 706.53.10, is quite when and in what circumstances that right could be exercised. And it appears that there are at least certain circumstances in which a request for deletion would be inadmissible.
It seems to be what you can't do it while you're still subject to the sentence.
That appears to be.
That's what it's saying.
Although, yeah.
Yes, we get an indication that paragraph 28. The government recognises, however, that any application for deletion is inadmissible in respect to matters listed in bulletin number 1. We haven't got bulletin number 1. And that in the case of the applicant, these entries would only be deleted once 40 years have elapsed.
Yes.
So there's some things on your record which have got to stay there for 40 years.
Yes. The only reference I found to bulletin number 1 was in paragraph 20, which describes the nature of the record and who has access to what bits of it. Do you see the second sub-paragraph within 20 refers to bulletin number 1?
If you go to the Ministry of Justice website, you will find a thing about it, Mr. Edie. It's not terrifically informative, but it tells you that it contains the entirety of all condemnations and decisions which are contained in the casier judiciaire, and with a few exceptions. So it really seems to have everything in it. But there are things which come off after a certain number of years and so on and so forth. So there's 3 bulletins if you're interested.
I'm grateful, that's helpful. But I think what is clear from that, whatever the circumstances in which the inadmissibility provision cuts in, what is clear is that this system was the composite one. It was dealing with conviction and wraparound information. No one was suggesting that there should be, as it were, a distinction or a division between, on the one hand, the conviction information, and on the other hand, the current address and all the wraparound information, which would give that some force.
So, I mean, it was taken as read, really, that if the conviction goes out, then the wraparound goes out too. That would be a logical
and vice versa.
situation.
If the conviction stays, the wraparound also stays, in order to give it practical punch, as it were. No one suggested one could split the two, and it's to be noted in the context of that point that no one in this case is mounting any challenge to the maintenance and retention of the conviction information, which, as we know from the Humberside case, can continue indefinitely, effectively, for the life of the offender. So when they're talking about the review in paragraph 66, 67 and 68 of the judgment, they're talking about a review after 40 years of the entirety of the information, including the conviction information, it would appear.
Not after 40 years, sure.
I thought that was the effect of para 28.
No, I mean, it remains, the maximum period it can remain on, isn't it?
That's the maximum, yes.
I think you can count. I think once you're, I mean, if you get sentenced to 10 years, then once you're 10 years or you've got your parole or whatever it is, once it's no longer affecting you, then you can then apply, I think. I think that's how it works, as far as I could understand. I may be wrong.
Well, there's the last sentence of 28.
Paragraph 28 is distinguishing between the conviction information and the other stuff. In respect of matters listed at bulletin number 1, and we know what's in bulletin number 1 because it says so in paragraph 20. This is not a very productive debate, Mr. Eady. I'm getting very concerned about your opponents, quite apart from your supporters.
My lady, I take it as shortly as I can, but it is an important point, because in my submission, the question of review that is being dealt with in the body of the judgment is a review which would apply to conviction information as well as the wraparound information. And in relation to, as we set out in our note in relation to the conviction information, in tab 1 of the black bundle I handed up this morning, it is possible under the Data Protection Act to seek a review of the retention of information held by the police of any kind, including conviction information. And you can do so on the grounds that it's excessive or it is being held for an unreasonably long period. That, after all, was the nature of the challenge in the Humberside case. That opportunity for review in relation to the conviction information exists as a matter of domestic law anyway in the Data Protection Act. So one does have a right of review in relation to that information, and there's no reason why that review should not also extend to the wraparound information. There's no certainty that you get the result that the person wants. And indeed, it's entirely predictable that the court on any such challenge, or the Information Commission and the tribunal on any such challenge, would say, well, in relation to the wraparound information, no. It's current, it's annual information, it's designed to be current. So it's not held for excessively long periods, and it's not excessive in its scope. So we do submit that there is an important point there, and that the domestic provisions that we have in the Data Protection Act mirror exactly the European directive, which we've also set out in our black bundle, and the European directive contains effectively exactly the same principles as are set out and collected at paragraphs 25 and 26 of the Court's judgment by reference to recommendations of Council of Ministers and so on. But we've got that opportunity in the Data Protection Act. It may not yield the result that my learned friends want, but the opportunity for review is there.
If one looks at paragraph 65 and onwards, Mr. Eady, I'm just trying to, I'm sorry, but 65 seems to deal with the actual giving of information,
Yeah.
which they just sweep aside as being perfectly all right in that case under citation of Adamson. And then they go on to the length of keeping the information, which is 66 to 68. And then 69 is use of the information. I mean, what I wasn't at all clear about is, do they regard the annual giving of the information as different from the keeping of the information, or how does it work?
Well, it's difficult to tell from that. My broader point is that there is, that the review which is referred to here applies to both types. So there's 2 points. One, it applies to both types here, so that needs to be borne in mind. Second thing is that, as a matter of domestic law, we've given effect to the EU directive to do with excessive length and excessive in scope in the Data Protection Act. And the opportunity for review, an equivalent opportunity for review exists here at any time, but the outcome is likely to be unsuccessful.
Yeah. I thought use was all part of the general assessment as to whether there had been a violation of Article 8. The wider the use of it, the more offensive the whole system might have been thought to be. But my impression is that they thought, well, the use of it is actually, it's limited to some extent, but it's only accessible by bodies with a duty of confidentiality and so on, and therefore there's a sort of reassurance, therefore, that the extent of the invasion of rights covered by Article 8 is not so great as to cause concern. So it's all part of the overall balance.
They have treated it, I think, as part of the overall balance. Whether they've analysed it separately as a discrete issue or as part of the overall balance, one could perhaps have an argument about it. It isn't entirely clear whether they're treating it as a separate point, but we covered use yesterday,
yes.
And in my submission there are plenty sufficient protections as a matter of domestic law to give one the degree of comfort required if it is to be regarded as part of, as it were, of the overall proportionality package. Perhaps the final point in relation to Bouchacourt is this, that they ultimately, you seem, found no violation of Article 8. They did so relying to some extent on the fact that there was a right to seek a review in that case. But it doesn't follow in my submission, and they did not state, that they were thereby implicitly asserting that such a review was an essential component of any scheme.
No, the highest it can be put is that they say the retention of data for so long a period could be problematic in terms of Article 8.
Yes, and then...
But the court notes the
reason
opportunity to apply for deletion.
Yeah. So one is simply back in my
And
submission.
I think the argument on the other side is that, it's not entirely clear, I quite understand that, but the underlying base idea you get from all this is that they regard it as a problem would be a problem under Article 8 if there were no right to apply for a review. There was a right to apply for a review, and that persuaded them from looking at the thing in the whole. There was no infringement of Article 8. I mean, that's the way I see it. I quite see that there are, in terms of detailed analysis, there are quite a number of potential problems and scope for argument. Yes, I quite follow that.
My Lord, there are. But I was really just addressing the broader way of putting it. Are they implicitly, as it were, acknowledging that without the right of review, there would be a problem? And in my submission, one can't jump to that inference or that conclusion. Apart from anything else, they weren't dealing with a regime where Parliament had made the judgment. They had no evidence before them as to whether that was a good thing or a bad thing. They were simply dealing with a system which already had within it a right of review, albeit of the composite information. And unsurprisingly, the French government relied on that.
And of course, it was not helped by the fact that the point wasn't raised by the applicant, and it had been, as pointed out in paragraph 48, and you see this summary of what the applicant says in 55. It was really something the court had thought up for itself.
Right.
So that doesn't make it easier to...
Quite. But the broader point is that they simply weren't addressing or grappling with a system such as ours, with the support or otherwise, which that provides. Now, if you're unconvinced by the reasoning to date, as it were, then Bush-Accord isn't going to help me. But in my submission, if you are convinced by the reasoning so far, then Bush-Accord doesn't stop you, if that makes sense.
I'm sorry, I'm not quite clear. You say that if you take the wraparound information, do you say it could be removed? Is there a position? What were you saying about the data protection?
Well, there is in domestic law in relation to the answer, if they tried to challenge, would be no, Parliament has prescribed in another act that it must be kept. It's a year-by-year thing and it's indefinite. They could certainly, however, mount under domestic law a challenge to the retention of conviction information under the Data Protection Act. And the records of the notification. And so one is dealing, as it were, with a distinction between those two types of information. That distinction does not exist in the context of the Bush-Accord case. I'm not suggesting that someone could go off and say under the DPA delete the wraparound information, because the complete answer would be Parliament has prescribed that it's necessary. But they could do that, and they did do that in the Humberside case. They could do that under the DPA, the Data Protection Act, in relation to the conviction information. I'm sorry, I've been reminded and I've taken too long anyway, but those are my submissions in opening.
Thank you, Mr. Johnson. Mr. Savvy?
I think the legal
Who's going next? Lord Advocate. Sorry. Yes, of course.
Lords and Lady, the Lord Advocate is grateful for the opportunity to intervene in this case. She does so because of its general importance to Scotland, to Scottish ministers, to Parliament, to those who operate the justice system in Scotland, and I venture to suggest the wider Scottish public. As my Lords have heard, the Sex Offenders Act 2003, although there are differences in the way it applies to Scotland, it does extend to Scotland. And so if the Home Secretary's appeal is refused in this case, there will be a declaration of incompatibility which will be within the devolved competence of the Scottish Parliament, and will be then for Scottish ministers and the Scottish Parliament to decide how to respond to that declaration of incompatibility. I just note in passing, my Lords, that there is, of course, a precedent for the Lord Advocate intervening in an English case, in the case of Alconbury, which, as it happens, is within the bundle at Volume 1, tab 6, in which, when I was Lord Advocate, I intervened in relation to planning matters, and there was an outstanding case in the Court of Session called County Property, which to some extent depended on the outcome of the Alconbury case. My Lords, I've heard a lot about A against the Scottish ministers. The present position in that is that there was a reclaiming motion heard in the First Division 2 weeks ago, I think the 19th, 20th and 21st of January, at the end of which the Lordships adjourned the hearing for the outcome of this case. As my lords will be aware from a lot of the facts in that resonance in the facts in this case, there's certainly one of them, and the principle of whether or not there can be indefinite registration without a right of review is one which is at the core of the case of A against Scottish ministers.
So would it be right to assume that the hearing will be resumed once judgment has been given?
Yes, ma'am. My lords, I'm very conscious of the time, and I've listened very carefully to what my learned friend Mr. Eadie has said, and I don't demur from anything he said and adopt his submissions, and I have to say I'm very grateful to him for explaining the differences between Scottish legislation and that in the rest of the United Kingdom. I have to say he did it much better than I could have done. There is one substantive point that I would wish to make with you, and that is in relation to the management of those on the register. In Scotland, the Management of Offenders Scotland Act 2005, which my lords will find at volume 9, tab 80, puts a responsibility on authorities for jointly establishing arrangements for the management of risk from certain categories of offenders, one of which is those who are subject to Part 2 of the Sex Offenders Act 2003.
So what was the reference, Mr.
It's volume 9, tab 80.
Which section are we looking at?
It's section 10.
Right. Yes.
And subsection 1, the responsible areas for a local authority must jointly establish arrangements for the assessment and management of the risks posed in that area by any person who is A, subject to notification requirements of Part 2 of the Sex Offenders Act 2003. The Lords will see at subsection 7 that the responsible authorities are the Chief Constable for the area, the local authority, a health board or a special health board for the area, and also finally Scottish ministers. Lord, how that is operated in Scotland is, as I understand it, very similar to England, because under that arrangement there is what is called MAPA, which is management arrangements, multi-agency public protection arrangements, MAPA, multi-agency public protection arrangements. And under that system, there are categories of risk. They go from level 1, which is categorized as low risk, to 2, medium risk, and 3, which is high risk. The Lords might find a helpful reference to that in the article which we've already looked at and is in the new bundle, which I think is tab 10 in the new bundle. The MAPA arrangements also make provision for the standardisation of assessment so that there is a consistent approach to the assessment of risk. It also provides enhanced management and supervision through the joint approach for those on the higher levels, that's levels 2 and 3. And that is done through joint panels of the responsible authorities who meet regularly to discuss those on the higher levels of risk. For level 2, as I understand it, these are simply frequently regular meetings, and on level 3, that can be ad hoc meetings as and when required. Sometimes it's required at very short notice. is perhaps perhaps to be noted, my lords, that under MAPA there is no risk category. The lowest is low risk. I think it's reinforcing the point that it is perhaps difficult to say that nobody poses no risk whatsoever. My lords, what this leads to is a management of risk with interventions which are then made possible as a result of that assessment. So that
interventions we're contemplating.
yes, exactly, my lords. The first one really is working with the offender through, for example, criminal justice social work, for him to recognise the risk that he poses and to address that issue.
This is for what purpose, this assessment?
It's, my lords, well, it is to promote reintegration and rehabilitation, but also to...
But is this before release?
No, it is after release. You can't, obviously it works before release in the prison system, but it is after release, when the person is on the sex offenders register, and every person is assessed as being at one of the categories, level 1, 2, 3. Now most people are level 1, which is the low risk, but there are those on the sex offenders register who are higher risk, levels 2 and 3.
I understand where you're going to. It's really, this is an indication of the value of the system, and you need to know whether people are all the time if you're going to make the system work.
Indeed, that is the short point.
That raises the question really of focusing on the level 1, because one can quite see that as far as level 2 and level 3 are concerned, you need the wraparound information in order to make sure that they get the rehabilitation. But once they've been through that, and you may say, well, we've done everything, and now they're out in the clear down to level 1. The issue we're concerned with is, do you have to preserve everything that goes with keeping the wraparound information up to date, ad infinitum, for the level 1?
Lord, I take that point, but the answer to it is that there is people can go down the scale, but they can also go up the scale.
But when you're in level 1,
Yes.
does that mean there's a continuing assessment of you
Well,
for the whole of the rest of your life? And where do we see that? Where is this explained in the documentation?
there is no explanation of that particular issue in the documentation.
But is that right? I mean, if you're at risk level 1, are you subject to some kind of supervision or assessment for the whole of the time you're on the register?
You're
not, are you?
Well, you.
I mean, you're just an entry in some database, aren't you? Nobody otherwise worries about you at all.
Well, I think that's.
But the state doesn't, does it? Or does it?
Well, they have to register and keep on the register to notify changes.
I understand that. You're on the register, but after that, you're simply on the register. There's no supervision, no assessment of your risk, is there? Is there or isn't there?
No, there isn't. There isn't an ongoing assessment of every single person who's on the register, as I understand it.
Despite the risk?
But the indicators can arise in respect of anybody who's on the register, and because they're on the register, then it is possible to make the intervention that is necessary to either put them up the scale into level 2 or even to level 3, and to make the interventions and to protect the public.
But they can only make interventions if they've got power to do it.
Yeah, but
And most of these people will no longer be subject, well,
But
a lot of these people will no longer be subject to any sort of compulsion other than to notify.
they're not under compulsion, that is true,
Yeah.
and it is not compulsive. But what is available to them is, for example, the social work, housing. Housing is very important for sex offenders in many instances, and ensuring that they are properly housed and appropriately housed as well. Offer of psychiatric care. The health board is part of the matter arrangement So it is potential help.
But do we see all this set out somewhere?
No, no more.
Does it all resting then on these, the opening line, 2 lines of subsection 1 of section 4? As I understand it, that's the statutory provision which you're telling us about. It's the assessment and management of the risks.
Yeah.
And it's not really spelled out very much in the section, but that seems to be the statutory duty.
Yes, and it brings together it puts a statutory duty on the responsible authorities to cooperate and work together to produce the outcome.
And to keep each one of these people under continual review.
Those who are on the higher levels.
No, I'm talking about the ones who are on level 1. Is there any obligation? Are you conceding on behalf of the government that there is an obligation to keep people in level 1 under continual review?
I'm not conceding that.
Yeah, right.
What I'm suggesting is
It's what the section says. It does say any person.
Section 11 talks about keeping the arrangements established by them under review.
yeah.
But
Section 10 is the initial duty which extends to any person who's on the register. And then 11 is under review. And the what it's talked about is not just a section.
Yes, but I'm not suggesting that every single person who is at level 1 has a risk assessment done on them periodically.
Why is that? Because there's no risk?
Because, well, there are
Or no
issues
significant
about-
risk?
there
Or
are
no
issues-
real risk?
There are issues
Otherwise you would.
Sorry, no, I didn't mean to cut across it. There are issues about you assess the risk so that you can appropriately target your resources on those who pose the higher risk.
And not on the level 1 people.
Well, clearly, on the sex offenders register, there are going to be different levels of risk. That follows, must follow. What we are saying is that there's nobody who is of no risk, of whom you could be confidently sure that will never commit a serious sexual offence again.
And where's the evidence of that?
Well,
We're now back to the evidence, the other bits of evidence we got in the case.
Yeah, I'm relying on that. Yeah. So, in other words, what I see is that this is an aid, first of all, for the protection of the public, secondly, to the reintegration and rehabilitation of the offenders, and in my submission, what the register does is provide a gateway to the assessment and management of risk. In other way, a mechanism whereby those who have been convicted of serious sexual offending can be monitored, assessed, and if need be, managed.
Can I just ask, you've been referring to the Scottish legislation, and you helpfully referred us back to Professor Thomas's article, which actually describes the situation very helpfully, seems to me, at page 261. Now I can read it. There appears to be equivalent English legislation.
I researched that, and I can certainly give more details on that.
Well, he refers to the Criminal Justice Act 2003, section 327A, which is a duty on the police and other responsible authorities of the MAPA to make a risk assessment of all those on the sex offender register, which sounds like exactly what you've been telling us. So it would be helpful, possibly, for us to know what the equivalent English legislation says.
My Lords, Lady, that was really the substantive point that I wanted to make. I was going to make some remarks in relation to the parliamentary material, but given the time and the fact that we've already had an extensive discussion of that this morning, I'll not do that. But there is parliamentary material quoted in our submissions at paragraphs 12, 13, 14 and 15 of our case.
It is when you talk about parliamentary, it's Westminster
The
Parliament.
Westminster parliamentary material. Quantum Valiat, there is also at paragraph 4 of the submissions reference to the discussion in the Scottish Parliament when the legislative consent motion was before the Parliament in relation to the 2003 Act, because of course my Lord will be aware, under the Sewell Convention, the UK Parliament does not legislate unless in the devolved area without the consent of the Scottish Parliament. We can make that material, the background material, available to my Lord immediately if you wish. If the appeal is unsuccessful and the declaration of incompatibility stands, then Scottish ministers will have effectively three options. The first is for an amendment in the United Kingdom Parliament to the 2003 Act. That would require a legislative consent motion. I suppose the only problem with that is a timing one, and that is a general election, which of course will come in the next few months. The second one is that the Scottish ministers promote legislation in the Scottish Parliament. And the third one is a remedial order either under Section 10 of the Human Rights Act or under Section 10 of the Convention Rights Compliance Scotland Act, which the Lords will find at tab 79. But there are remedies available to Scottish ministers and Scottish Parliament, as well as at Westminster, should that be necessary. And with those remarks, Lord and Lady, unless I can be of any further assistance, I close my submissions.
Thank you very much, Lord Boyd.
Lords and ladies, I hope, particularly given the time, that it will help if I at least start by summarising the position of the first respondent and also just emphasising 3 points that we say are of particular importance when looking at those the position that the first respondent takes. First respondent says that essentially there are two key issues raised by this appeal. First is whether the interference with Article 8 is a significant one. And in relation to that, we say that it is, both because it's now clear, following Marper and Bouchicourt, that data retention on its own is regarded as significant by the European Court. And that's plainly a matter of some importance. But secondly, also, because the Court of Appeal were right in recognising that the obligations imposed under the English scheme place a very significant burden on the person in the first respondent's position. So, for both reasons, we say there's a significant interference. The second issue is whether the interference is proportionate, and we say it is because there's at no stage is there any consideration given to whether the continuing obligations that the first respondent faces are necessary. And in that sense, I mean, what I mean by that is there's no review at any stage of whether the risk is sufficient to justify the interference with Article 8 rights, whether there is a real risk.
The word continued interference.
The continued.
I don't think you're challenging the initial decision.
No, that's why I talked about a review mechanism in this context. It's the continuing, it's the continuing obligation. And the 3 points that we would sort of make in opening as being points that we particularly invite the Court to focus on. Firstly, we do say that Bouchicourt can't be dismissed in the way that my learned friend has attempted to, because it is the first judgment of the European Court, as opposed to an admissibility decision, looking at the compatibility of sex offender registration with Article 8. And although it is a decision, and I'll come back to this, that was is of a chamber rather than the Grand Chamber, it's quite clear in terms of the principles it applies, we say, that it builds on Essen Marper. And Essen Marper, of course, is a Grand Chamber decision considering the situation in the United Kingdom. The second point that we'd emphasise as being particularly important in the first respondent's case is the fact that he's a child. And that is important, we say, for at least three reasons. Firstly, one needs, sometimes when looking at proportionality, to look at common sense. In the first respondent's case, he may well be on the register for 50 or 60 years. Is it really proportionate that in 50, 60 years' time, if he hasn't offended during that period, that he should still be required to register? We can't ignore that, particularly in his circumstance, because it's a real problem that he faces. The second point is that his age at the time of his offence means that he has, we say, a particular capacity for change, and that's been acknowledged in the case law. And that means that it's possibly easier for him to justify, albeit to demonstrate rather, the fact that registration is no longer necessary, because children have that capacity to change. Whether adults do may be open to debate, but children clearly do. And the third reason why it matters that he's a child is because there is a particular need to rehabilitate children. However, in the first respondent's position, he knows that the stigma of sex offender registration will be with him for the rest of his life, whatever he does. For all those three reasons, we say the position of children does need to be considered. One can't just say that there's no difference between children and adults. The third point I'd make, and particularly wish to emphasise, is that there is no precedent in Europe that we've been able to identify for a system that both lacks a review mechanism and doesn't take account, in this context, of age. Except, of course, if one's sentenced to less than 2.5 years, account is taken of age. But in the respondent's position, no account is taken of his age.
I think according to the European Court, only the UK and France have sex offenders thing, plus some parts of Germany or something like that.
That wasn't actually quite accurate. In the Ireland, we've produced the material that an Ireland has a system where, from memory, and we'll go to it later, but from memory, for children, it's limited to 10 years. But for adults, there is a review mechanism, and we'll go to that. But also in relation to other forms of offending within the United Kingdom, there is no precedent. And one of the materials we had up, which is referred to in our case, is the Counter-Terrorism Act 2008. If the first respondent had been convicted of a terrorism offence, there is now an equivalent to the sex offender registration scheme, but he'd be on it for 10 years. He'd have the opportunity to rehabilitate. And one can... Nobody, certainly from the respondent's side, would argue that, of course, preventing sex offending isn't important. It's a serious threat to vulnerable people. But terrorism is plainly also at least an equivalent threat. So those are the opening points. And with those, if I can, I'll go straight to the extent of the interference, and in particular, starting off with Bouchicourt, because although in Mullen and Friends submissions, the Bouchicourt was referred to particularly in the context of proportionality, the balance, it is important also because it does, in my submission, give clear guidance as to the significance of the interference. And Bouchicourt is, of course, in bundle 6, rather, tab 55. And Bouchicourt, of course, was an adult, so there was no particular consideration of the position of children in that context. The position was that, I don't think there's any dispute about that, about this, the obligations, and they were set out in a notice to him, one sees at paragraph 9, were less demanding than those in the United Kingdom. He was required to confirm his address once a year and notify any change of address. And perhaps of some significance, he was able to do that by recorded delivery letter. One sees that from the statute. So one doesn't have the same sort of problems that necessarily the Court of Appeal identified in the respondent's case, where the fact of offending might be identified by the obligations imposed. The register, there are figures in the judgment about the size of the French register, and they're of some relevance given the arguments put about resources. And one sees in particular at paragraph 19 that there were 20,222 people on the register when it was first opened. And by October 2008, that had gone up to 43,408. So we can see that the scale was at least, or the size of the register was at least equivalent to that in the United Kingdom. And there is no dispute that there was, in that case, a review mechanism. There's been a certain amount of debate about when one can apply and in what circumstances, arising from the second paragraph of the relevant provision of French law. The best I can do in terms of the best I've been able to do in terms of identifying the position, which is to some extent inconsistent with my learned friend's submissions, is to note the government's submissions at paragraph 53, which record the fact that that an application is inadmissible if the record of conviction, if there's a record of conviction on the applicant's criminal record. But it then goes on to say that the record of conviction can be removed, essentially.
If there's legal rehabilitation, is that the trigger?
That seems to be the trigger, and there's a reference. One sees the process of rehabilitation described at paragraphs 21 and 22. Yeah. It seems that there's an automatic rehabilitation after 10 years, where it's a 10-year sentence. But there does also appear to be. Sorry, yes, I think that's right. But there's also does seem to be some sort of mechanism for taking proceedings for rehabilitation, which is consistent with the French government's submissions, that they would appear to be. So this isn't a sort of a composite process, as my learned friend perhaps described it. There is a separate record of conviction, essentially, it appears to be the case, and one can apply. But one can apply to be discharged from that, and then one can apply to be discharged from the register. So overall, one can apply to be discharged from the register. Article 8 was, of course, considered, as we're all familiar with, I accept in the context of an application that didn't raise Article 8, but it's very clear from the submissions that, from paragraph 48 onwards, that the way in which it was raised, not surprisingly, allowed the parties an opportunity to address the issues. The key reasoning in our submission really starts at paragraph 57. And paragraph 57, in my submission, I'll come on to MARPA in a moment, it is a straightforward application, essentially. Well, paragraph 57 and then paragraph and later applications is an application, the approach that was taken in MARPA. Paragraph 57 records, of course, that both the storing of data is an interference with Article 8, and also the obligations to supply information to the Sex Offender Register is an interference with Article 8. That's not surprising, as I say, in light of MARPA, because MARPA makes it clear that the storing of data is an interference with Article 8. What's then important, though, is that the court then, at paragraph 60, when looking at the context of marginal appreciation, says, when a particularly important aspect of the existence of identity of an individual is at stake, the margin of appreciation left to the state is generally limited, implying that because this is a significant area, the margin of appreciation is reduced. Obviously, if this was a trivial interference with Article 8, one could see that there'd be a very wide margin of appreciation. And that's then confirmed, essentially, in paragraph 61, where the court, directly, effectively applying MARPA, says that the protection of personal data plays a fundamental role, and I obviously emphasise the words fundamental, in the exercise of right to respect for family life. The domestic legislation must, and no discretion there, therefore provides appropriate safeguards to prevent any use of personal data. Following the use of S and MARPA, the court is of the opinion that the necessity of those safeguards is all the greater when the personal data is subject to automatic processing, particularly when the data is used for police purposes. And that's important, my lord, because it recognises that one has concerns whenever data is held, but one has particular concerns in this sort of context. So the margin of appreciation narrows further. And then one has...
I think there's a no missing in the next sentence.
Well, I thought that at first, and I've tried to check.
Well, I've looked at the French.
Oh, right. My lady has an advantage that I have in that my French is appalling, to be completely frank. But I think the sentence is clear.
Kept for no longer than is necessary.
Yes. Yeah. The point is, there has to be a mechanism where you can identify people whose data doesn't need to be held any longer. And that's the fundamental problem here. That's a statement of principle, and we'll see in a moment, it comes clearly from S. Marper. But there is no mechanism in this case. The court then went on to accept the objectives of sex offender registration at paragraph 62, but then also at paragraph 63, and this is important in my submission as well, it emphasised the reintegration of offenders. And that's important because it comes back to the point I made in opening, that the respondent's age means that rehabilitation is particularly important in the context of his case. And yet he remains with the stigma hanging over him for the rest of his life. Court then looked at Adamson at paragraph 65 and essentially noted that was about the obligation to notify, suggesting that the way in which the court viewed the admissibility decisions was not about the continuing obligation in the absence of a review, but about the initial obligation to notify.
So what point do you make?
Sorry, paragraph 65.
I've got the point, paragraph. What was the point you were making?
Well, I was suggesting that when one looks at Adamson and the weight to be attached to Adamson and Massey, what the European Court is saying, essentially, in paragraph 65, is that those decisions were about the obligation to register, the requirement. They weren't about the fact that there's no obligation to review, that there's no opportunity for review.
Yes, so 66 is moving to the point that really interests you.
66 is then, 65 is saying that those cases are about something else. 66 is then moving to the point that interests us.
Where's Massey cited?
Well, I mean, 65 seems to be dealing with the question, does it not, as to whether or not you could say that the actual notification was an infringement which was too great, disproportionate, and they seem to sweep that aside rather, and then they go on to the question of the duration of the thing.
Yes, but that's the point I'm making is they do sweep that aside, but they do it effectively suggesting that is what Adamson is about, and of course.
Well, that's what Adamson was about.
Yeah.
Well, it wasn't. Absolutely.
Compare Massey, which may take it a step further.
Well, we would say not. We would say Massey just, and I'll come on to Massey. That Massey just builds on Adamson, but the critical point, as I think we're agreed, is then paragraph 66, 67. 68, essentially.
But just sticking with 65, are you saying that in our case, when we look at the more burdensome nature of the obligations that arise under the English legislation, it's not as easy as they seem to suggest it is in 65 to sort of say, well, that's all right on Adamson? Are you saying that if you're looking at the overall assessment, then you look at the degree of interference, the problems which have been given by the Court of Appeal in its appendix of sort of meeting the requirements in particular situations that might arise, that kind of thing?
I'll answer that question this way. We say that it is relevant to look at the particular burdens, and we say that it's relevant to look at them not in the way that they were looked at in Adamson, because Adamson was essentially looking at the starting point, if one likes, of the process. It's relevant to look at them because one needs to recognise that the obligations will go on for 30, 40, 50, however long, 30, 40, 50 years, however long, depending on the person's age. And then when looking at the points of paragraph 66, 67, 68, the significance of the interference needs to be taken into account when looking at whether or not there are adequate procedural safeguards. And the significance of the interference becomes relevant in that context. I hope that answers my Lord's question.
Did you say that you couldn't take that we couldn't, on any view, take the view that given that the whole point of it was to try and prevent sexual offending and to protect victims and so on, that the regime which was introduced, leaving aside the duration of the thing, but just leaving aside the duration, but just the regime of notification, travel orders, all these sort of things would be disproportionate.
No, I think our position, this is why we're talking about a review, is that at the time of conviction, of course, one has an immediate finding that one has been guilty of a serious criminal offence. And the state the state does impose obligations at that stage. It will have licence requirements that require somebody to report to the probation service. However, as time goes on, those requirements may become disproportionate.
So if you had got a shorter sentence and got 5 years,
Yes.
which would still be running as far as I understand, you would not be saying that it was disproportionate.
It would be much, much more difficult, yes, because the 5-year period would be much easier for the state essentially to say that the offending demonstrated that there was a need to monitor for.
You're really
for 5
complaining
years.
about what's going to happen in the future.
Yeah, yes, but it's.
I mean, nobody's suggested so far, have they, that it's disproportionate not to have a review in relation to the non-indefinite cases. That's to say, in the cases of the finite periods in the statute. Nobody has suggested so far, have they, that the absence of a review scheme rendered those provisions unlawful.
No.
Unlawful.
And one of the reasons for that is that when I started and made the remarks about how this is an unprecedented scheme, if one were to put into the scheme, if one were to create a review scheme and when one were to have, say, a minimum period of 10 years before one applies, one then wouldn't have an unprecedented review scheme. And one would see then an analogy between the person who had a time-limited review, which wouldn't, a time limit rather on their registration obligations, and the person who was seeking a review. Comparison. But paragraph 67, 68, and 69 are obviously important because we say they contain a very strong indication that had there not been a review mechanism, which obviously there isn't in the United Kingdom, the system would have been found disproportionate. But that, of course, they shouldn't be read in isolation. The reason why that conclusion was reached was paragraph 61, where the court is emphasising the significance of the interference with Article 8 and the need in those circumstances for an individual decision-making process to decide whether or not continued retention is necessary. And so one doesn't have sort of 67, 68, and 67 and 68 in isolation.
It's slightly, I mean, I must say I found it slightly difficult to follow. I mean, because one thing they're talking in there is about the length of time for which the data is kept. Now, every year you give in new data, and so it can't be that. I mean, how does it work?
Well, I think if you look at, I've been grappling with the same thing. If you look back to Article 706-53-2,
Two. Yes.
So which seven?
That's in paragraph 16,
about-
the beginning of paragraph 16.
About 5 pages in.
Yes,
Yes.
thank you.
where subject to the provisions of the last paragraph, one or more offences, there is recorded on the database information relating to the identity, the address, home addresses, and so on of the persons who are convicted. And so, as I read it, 65 is simply an obligation to keep the data up to date. But once the data is struck off, there's no longer any obligation, annual obligation to notify changes of address.
I mean, well, that's, with respect, consistent with common sense, in the sense that if one had a system where the data retention alone was protected, and so one had a decision that data couldn't be retained because it wasn't proportionate to retain the data, to require someone to go to the police station and say, I've moved address,
yes,
knowing that the data is immediately going to be deleted, would of course be patently
In
disproportionate.
Mr. Eadie's language, there's no point in having wraparound information if it isn't wrapped around something.
Exactly. So although it's rephrased in terms of data protection, one can't just look at it in that way, because that doesn't make any sense, essentially. Well, that I hope deals with the judgment fairly fully, but in sufficient detail. But it is important to put it in the context, as I say, of Essen Marper versus the United Kingdom, which is a little earlier, which is at tab 53. Now, of course, I accept that in that context, the context was very different. And I was talking about retaining material from people who'd never been convicted of an offence, and one might say that the data was more sensitive. But the principles in my submission are clear, and they are, not surprisingly, because it tends to be the way Strasbourg works, effectively restated and then applied in Bouchicourt. One point that I don't think we've been to in relation to it, but is just worth noting, paragraph 67, is that in the context of looking at whether or not there is an interference with Article 8, the court notes that one does need to look at the specific context in which information has been recorded and the way in which the records are used. And I just draw attention to that because when one looks at the issue of whether the Court of Appeal were correct or were allowed to consider the examples that they considered of...
This is paragraph 67 of Marper, is it?
Sorry, paragraph 67 of Marper. Yes. Sorry, sorry. I was going ahead of myself.
No, that's my fault.
Sorry.
So we're tab 53.
Sorry, tab 53, yes.
Yes.
It does talk about the need to consider the specific context and in particular the way in which the records are used. And in my submission, that demonstrates that one can do what the Court of Appeal did, which is look at the realities of the way in which this sort of information is used when looking at the extent to which there's an interference with Article 8. The key paragraphs, though, in my submission, probably are paragraphs 102 and 103. And there, I don't think I need to read them all, and I'm sure you will read them in your own time. But the critical point there is one sees there the statements of principle which are then applied in Bouchicourt. In particular, one sees there the statement of principle that there's particular sensitivity about what's described as automatic data processing by the police. And one sees there also the emphasis on the need for safeguards to ensure that the data isn't retained for longer than necessary. And that is the foundation of Bouchicourt.
And I think the answer to our little point about the translation is in paragraph 103.
Yes. Well,
because paragraph 61 is a direct quote from paragraph 103,
yes,
isn't it?
Thank you. Thank you, my lady. Just a few other points I should make about Marper. But as I say, the critical point, most important point about Marper in my submission is it demonstrates that Bouchicourt is not some novel development. It's the inevitable consequence, we would say, of Marper. A few other points, though, that I would make. Firstly, my own friend in our submissions noted and suggested that the European Court had approved the Scottish system of DNA retention, and that's at paragraphs 109 and 110. But Lord, that, in my submission, that doesn't really assist with the issues here. Firstly, because the retention of data was time limited there, it was for a pretty short period of time. Secondly, all the European Court was actually saying in that context was that it was consistent with one of the recommendations of the Council of Europe about police data retention. What it didn't say was it was consistent with what is probably the key recommendation of the Council of Europe in this context, which is recommendation 8715, which is at paragraph 42 of the Court's judgment. And that's the recommendation that says that one needs to limit data to that which is necessary, essentially.
Well, of course, they say it is necessary because there's always a risk.
Well, I will come on to that, but with that, I mean, the European Court would I mean, one goes back to Boucher. The European Court would have been conscious of the fact that sex offenders who've offended may be said to pose a risk, but they were clear that the one needs a mechanism so that people who say, well, actually, I don't pose, on the facts of my particular case, I don't pose an unacceptable risk, can have that reviewed.
So we're looking, you get some guidance from 104, then that the intrinsically private character of this information calls for careful scrutiny in regard to its retention and use. So, I mean, that's just the exercise we're told to conduct here, and isn't it?
Yes, but in some way that is important, and that is the exercise that needs to be conducted. But it needs also to be read in light of paragraph 103, which is making it clear that because this data is held by the police, that's the fundamental thing that causes it to be particularly sensitive.
So the scrutiny, I'm sorry, I'm just introducing that because that reflects back on the middle of paragraph 103.
Yes.
And that in particular is no longer the necessary point.
Mm. Yes, absolutely.
Here, what is sensitive is the entry on the register. I mean, it can't be. I wouldn't have thought his address would be particularly sensitive, would it?
Well, firstly, one needs to recognise the European Court in Boucher regarded actually less data as being particularly sensitive. That seemed to be the approach it took. And in my submission, that's not surprising, because if one looks at the reality of the register, what the register does, as my learned friend says, is it links the fact of quite sensitive conduct in the past, conduct that somebody is likely to want to keep very private, even if it was notorious at the time, with a particular address, with a particular lifestyle potentially, because we have travel details, and with an identity. And it links in, that's why the data is potentially quite significant, because it's linking up the fact of a previous conviction with a current person who can easily be identified from the register.
I suppose it's not all that different from the DNA sample, which itself is neutral.
Yes.
It all depends what people are going to do with it, and why it's there and what it's going to be used for.
Well, that's exactly why safeguard. I mean, one of the criticisms, and it's clear in MARPA, was that there weren't sufficient safeguards essentially to protect the data, even though it's quite clear that there were safeguards against improper use. There were provisions to make sure that the data wasn't used, for example, for sort of genetic purposes. It had to be used for legitimate crime detection purposes. But that wasn't sufficient protection because there was also the need, the European Court, we say, indicated, for a review of whether the retention alone could be was justified. And that's not surprising in my submission, because once one has a database...
Well, that's because of the risk that databases always leak, or hopelessly shambolic, or whatever. Because presumably the worry here is if one could be sure that all this material was going to be kept on some computer and never going to be misused, that would be one thing. If, on the other hand, there's a significant risk that the data, the addresses and so on, will come into the public domain to enable vigilantes, for example, to make the person's life a misery or whatever, then the position is obviously different.
Well, but in that context, and I was going to come on to that, but it's exactly, one needs to recognise that the issue for the police here, and we don't disagree that, for example, if disclosure is to be lawful, it needs to be demonstrated that it's necessary. But the difficulty for any police officer is judging that, and police officers in good faith, acting sort of in their eyes reasonably, may well judge that wrongly. And one can see on the facts of F's case, one can see all sorts of arguments about whether or not it was proportionate or necessary to tell the rugby football league that he was on the sex offender register. But that happened. And it happened without him having any opportunity to do anything about it. And that's the risk of the register, is that it increases that. The risk of the register increases that, because if one has a register, it firstly does carry with it a stigma. It suggests that somebody needs to be watched, essentially. And secondly, it gives the police the opportunity to tell people, possibly in good faith, but wrongly, that they believe that.
But your argument here will not help you in the case of the rugby football, the league club point, will it?
Well,
Because you're not seeking a review of the kind you would need in order to stop the disclosure of that type of information. You'd have to have some kind of very complicated system.
No, we're not seeking that, but it would help in this sense, in the sense that if the first respondent were to be able to demonstrate that he is low risk, and so the data didn't need to be retained, when the Rugby Football League go and approach the Greater Manchester Police, as it appears from the evidence they did, at that stage, the Greater Manchester Police will know that this person is somebody who's demonstrated that they are, if they find the criminal record, they will know that they're somebody who's demonstrated that they no longer need to be on the register, and it will be very difficult for the Greater Manchester Police to justify disclosing the material, and it demonstrates effectively that the need for the retention is no longer present on the facts of the particular case. And so one can see that if the first respondent had been able to demonstrate he shouldn't be on the register, that may well have given him protection against what happened with the Rugby Football League.
But you're not saying he should have had it in this case, because it's within 5 years, and you say if it had been a 5-year thing, he wouldn't have.
I accept that, but the reason the point I'm making about the Rugby Football League is it demonstrates why this data is sensitive. What happened there demonstrates the potential sensitivity. And okay, that may have been justifiable at the particular point in time, but if one goes 40 years forward, and this appellant, this respondent rather, has I don't know, has got a family, he goes to his rugby league team and says, I'm willing to offer a stand as a coach. The fact he's on the sex offender register could still be disclosed in the same way.
I mean, the police could also disclose his previous convictions from the police national computer. And are you saying that makes it, retention of data on the police national computer something which is disproportionate?
I think I'd give two answers to that. One is, Bouchicourt potentially does raise issues about the current approach to the police national computer because it emphasises, and Mark, because it emphasises retention of data. Like that, that's not the appeal that we've got before us. But the second and more practical point is the point I was making to my Lord Clerk, which was that if one has the ability to apply to the to be removed from the register, and one has a finding that registration is no longer necessary because the level of risk is low, it will be difficult in those circumstances for the police to justify disclosure.
But this really goes to the importance of having the principle which the European Court has, namely that it should be no longer than necessary, kept no longer than necessary. So it's just supporting that, really. In our case, I mean, you could invent all kinds of arguments you might advance in some other case.
Yeah, but I mean, fundamentally, it comes back to what the importance in this case, because whether the examples I've given are good or bad, hopefully doesn't matter hugely. What matters is the fact that when one has a database, it is there for use, and once it's being used, it can be misused perfectly in good faith. I'm not suggesting police officers are going around necessarily and deliberately abusing their access to them, but once a register is there, databases get misused for good reason.
There is also the aspect, I suppose, that the way this system actually has to work in practice involves somebody going quite visibly to the police station, and there may be occasions when that reveals things to people who should not normally be unrevealed.
Well, that is a particular problem. I mean, I was going to come on to the way in which it operates, in my submission, is a significant interference, or a significant burden for two reasons, really. One is because, as my Lord says, the physical need to go to the police station, on occasion, may reveal things that somebody doesn't want to erase. But the other thing is that these are, as I think we saw yesterday morning, complex and demanding obligations that people are likely to misunderstand. And the the rate of conviction and caution, they demonstrate that. Both in the Court of Appeal and in this court, people have found difficulty understanding it. But the obligations in relation to travel are quite demanding. One needs to supply all sorts of details about where one's going to land and details like that. And you've got to add into that the fact that, of course, not only does one have to physically present oneself, and that may result in this information being disclosed, but one has to give advance notice in relation to travel. And one can see that potentially being a very significant problem.
If that's a way, if it's rationally connected with the prevention of sexual crime, can you say that that in itself would make it a disproportion?
But the point we come back to is that one needs to look at whether that is rationally connected on the particular facts of a case, and that's why one needs a review mechanism. Of course, if somebody is a level 3...
It's back to review.
Exactly. I mean, my lord, that's why all our submissions, all the way through from the Divisional Court, have focused on the absence of a review mechanism rather than anything else. It's because I can completely understand that requiring somebody to inform the police before they travel is proportionate if one's a level 3 mapper, high-risk person subject to intensive review. One can see why that would be proportionate. At the other end of the scale, one has somebody, which is potentially what the first respondent, the position the first respondent will be in. One has somebody who has not offended for 40 years, who is in no way behaving in a risky manner, who is still, every time he travels to France on business, which is what he has to do, required to give at least 24 hours notice. And that's why one needs a review mechanism to distinguish between the latter class and the first class. And that's what, effectively, the European Court in both Marper and Bouchicourt were emphasising. And although it's true to say, as my learned friend did, one can draw distinctions between Marper, it's clear that a number of the features that cause the court concern are present here. The failure to take account of the age of the suspected offender. Well, that's clear here. And I know that the first respondent's sentence would have been reduced as a result of his age, but ultimately he is still subject to registration requirements that are identical with somebody who would have committed an equivalent offence. And that, in our submission, and I'll come on to this, is inconsistent with the UN Convention. And that's a point that the European Court emphasised in Marper at paragraph 24. The European Court was plainly concerned that it was open-ended protection, and that's clearly the case here. One also needs to recognise that the court was very concerned about stigma. One sees that at paragraph 122. I accept that was in the context of somebody who'd never been convicted. But here, in fact, in some ways, the stigma is greater in circumstances where, applying the approach in Bouchicourt, somebody is entitled potentially to rehabilitation. The fact that somebody's sex offending is revealed 40 years after it took place might well have much greater implications in terms of stigma than the fact that somebody's DNA is retained by the police. So, I think, hopefully, I've made clear what our position is in relation to both Marper and Bouchicourt, which is Marper is the foundation of Bouchicourt. Both demonstrate that there is particular sensitivity where data is retained by the police. Both demonstrate as a result there needs to be a review mechanism to determine whether or not that is necessary. And of course, here we don't have that review mechanism. I think I've dealt, in answer to questions, with the next point I was going to make, which is that there are significant differences between the French system and the United Kingdom system, the English system, in that the English system imposes greater burdens, and one can see, for the reasons that I've given, how one can, it's very easy to conceive, in ways that perhaps were more difficult in the French system, how the registration requirements give rise to previous convictions being revealed. And, as I say, the obligations themselves are demanding. So all of those matters we state demonstrate that effectively some of the remarks that were made in Gallagher and in Scottish ministers about this being an inconvenience are wrong. In part, that is because those judgments were both delivered before SMR and Lucian Court, and as a result, didn't recognise, for understandable reasons, the sensitivity that is attached to data retention by the European Court. So that is the context in which proportionality needs to be assessed, or part of the context, and I'll come on to other aspects of the context in a moment. It's part of the context in which proportionality needs to be assessed, because it plainly the starting point in proportionality is to look at the significance of the interference. That's the next point that needs to be considered when looking at proportionality, is to remember that the fundamental issue following the claim, as emphasised by Lord Bingham in that case, is whether the interests of society outweigh the interests of the person under review. And that is important because there was a lot of discussion yesterday about no risk and whether somebody would ever be able to demonstrate no risk. And in my submission, that is something of a red herring, because the issue here is whether the level of risk justifies the interference, whether the balance is correct. That's important because it's very easy to get hung up on concepts of no risk, but the reality is that if one looks statistically, everyone in this room poses a risk to children. I mean, if one, to look at, probably easier to look at me because anything else is going to be invidious, but one can put me in the category of men. Men commit offences against sex offenders. Against children. One of the puts me in the category of 40 to 50-year-old who've never committed a previous conviction against children. Plenty of men who are 40 to 50 commit sex offences, even though they've never previously offended against children. So statistically, I'm a risk.
Well, the system, unlike the retention of DNA, this system operates only if there's a conviction. Am I right? I mean, you have people, we all know, with people who are charged with these crimes and they're acquitted, but there may be something behind it, and maybe a cause for concern, but it doesn't operate in their cases. And one knows of some dramatic cases where somebody has been acquitted time and time again, and yet ultimately he's caught, and you realise that he's been behaving this way for years.
It does, but the reason I was making the point about the level of risk that I pose is that, of course, this is about balance, in that nobody would suggest, hopefully, that I should be subject to sex offender registration, because that would be disproportionate. It would be the start of the police state if I had to go to the police station every time I travelled abroad. The issue is, what is an unacceptable risk? When has somebody demonstrated that the risk justifies these intrusive obligations? And the point about that is that, of course, at the point of conviction, once someone's been found guilty at that point in time of serious offence, and that may well give rise to a presumption. But over time, that presumption becomes less and less valid. And so, going back to the situation of the first respondent, if the first respondent doesn't offend for, say, 40 years, he's really in a different position to the position that I'm in. I mean, in those circumstances, it's reasonable to assume that and particularly if there's material to justify it, that he's sought to rehabilitate himself, he's matured, and he's a very different person to the person who offended when he was alive. So the issue is, does he then pose a significant risk? And that's where the balance comes in. Is the balance, is it a real risk here? I mean, of course, were this scheme to be declared incompatible, there would inevitably be debate in Parliament about where one sets the barrier, and when one comes to the foreign jurisdictions, one sees a range of there is a point that conceptually there is a need for the state to look at the risk in individuals and say, does this actually justify these intrusive obligations? That's the critical point about this case, is that there is no mechanism. One has somebody who offends when they're 11 as a result of immaturity, and who does all their work, who then doesn't offend for many years, being treated in exactly the same way as a level 3 MAPA offender, the serial paedophile who repeatedly offended and who supervision demonstrates that they are behaving in a risky way. There's just no discrimination. And that's all we say, there needs to be a mechanism for that.
And do you suggest it might be a statistical table that wouldn't require individual assessment by with psychiatrists and so on, but simply statistically you could demonstrate that for this type of offence with no reoffending for 30 years, the statistical risk would be no more than that which attached to any member of society. And once you reach that stage, then it's disproportionate to insist that the individual continues to register.
I think probably one could conceptually do it that way, but I think there are dangers with that, because I think fundamentally this is about individual balance. And one sees, when one looks at, I mean, one of the things I was going to come on to, and I'll come back to this subject, is that there are a range of circumstances where courts and public authorities do carry out individual balances. They make individual risk assessments. And that makes sense, because if one looks at statistical evidence, one ends up with a situation that everyone in this room poses a risk to children statistically. But that's not the correct approach. What one knows is, in reality, people do make individual assessments, because they look at things like the extent to which somebody has engaged with their offending behaviour, the extent to which somebody has addressed risk factors that were present in their case, the extent to which somebody has all those are matters that the courts are actually really good at assessing.
I think that's how the licensing system works, where a life prisoner has been released on license. Initially, there's a very close watch kept of the individual. No doubt there are obligations to keep the parole board informed about where the individual is and so on, but gradually the system relaxes itself, and ultimately you may find that in practice there's no supervision at all, because the person is judged to be of no risk. Now, is there something which marks these particular crimes out from the generality of the violent offender who's actually committed a homicide and is subject to the licensing system?
Well, that's correct, Lord. The fact, I can't remember where it is in the bundle, but I should probably be assisting at the moment with that. We, for example, exhibit the life manual, which is the prison services manual.
Yes.
Or it's in one of the authority papers, the life manual. And that makes reference to the fact that where somebody is released on licence from a determined sentence, supervision, they can apply after a period to have supervision removed. In most cases, that would be after tab 114 at bundle 11. We I think, spared the court the full life manual. At paragraph 13.9.2.
Yes.
And one sees there that if one's on licence, there are all sorts of factors that are brought into account, and one can and the state will consider cancelling supervision after four years without offending. In the case of sex offenders, it's 10 years.
Sorry, which paragraph is that?
Sorry, paragraph 13.9.2.
Thank you.
It's headed at the top, page 7.
Yeah. So particular regard is had to sex offenders, but there is still a system that they can live with.
Yes, and in fact, that system is sort of, in some ways, now reinforced by the fact that in relation to IPP offenders, of course, the difference between an IPP offender and a life sentence offender is that somebody who's serving an IPP can apply not merely to be released, but to have the licence discharged. And that's set out in section in the in Schedule 18 to the Criminal Justice Act 2003. I don't think we need to go to it particularly, but it's tab 70, if your Lordship's notes, Lordship and Ladyship's note, in Bundle 8. And the test is the same essentially as for release, which is whether it's no longer necessary to have this supervision. So one sees that if the first respondent had received an IPP for a sexual offence, he would be able to go to the parole board and say, I no longer pose a risk. Or
Is
I
that
no
the
longer.
test?
Sorry, it's no longer
How is
necessary. No longer necessary. And
To
so
do
the statutory test is it's. Sorry, I think we need to go. Yes, it's tab 70, volume 8. Page 11. And what one sees there it's an insertion into the Crime Sentences Act 1997, which at subparagraph 4 of section 31A sets out the test, which is that the parole board shall be satisfied that it's no longer necessary for the protection of the public. The licence will remain in force. Direct the Secretary of State to make an order that the licence is cease to have effect. Now, given that the IPP, that can only occur 10 years after the person's release, I think it was recommended, there is absolutely no case law considering, I think it's one of the few things I can be certain about, has no consideration, no case law, because nobody could yet be in a position to make that application. But it clearly demonstrates how the parole board, for example, is trusted to make judgments about no real risk.
And would that would include any notification provisions, would it, which form part of the licence?
Yes. 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 And that's an annual, one has the right to apply annually. And so, for an inference, the parole board has to assess individual risk because of the fact.
I mean, sorry, are these licenses the ones where you can be recalled to prison?
Yes.
Yeah.
Yes. And so this isn't directly about liberty. This is about restrictions effectively on somebody who's in the community.
Yes, and who can then be recalled if he offends, is that right?
I accept, but liberty is not directly an issue because, of course, if he is recalled, there would be a parole board review of that.
Yeah, well,
It's more about the fact he's subject to. I mean, in circumstances where one's likely to make such an application, one's looking at somebody who's presumably been out and low risk, who's applying, there's no reason to believe that they are.
But if your application to discharge the licence succeeds, then you're no longer subject to recall. Is that right? Unlike a lifer, properly so called.
Yes.
Absolutely. Well, that's effectively the only real difference between an IPP case and a lifer is that the IPP person can apply to parole board for discharge of the licence.
Although even in the case of the lifer, in practice, ultimately you may find that that the system of supervision is simply gone because it's no longer regarded as necessary.
Absolutely, and that's clear from the lifer manual. And that's,
Yes.
although that's an administrative decision.
And I think that's quite common because, I mean, there are lots of people who are sentenced to life imprisonment for murder, where they've murdered perhaps their husband or wife years and years ago, and they have the idea that there's any further risk is perfectly ridiculous.
And it
I'm not saying that's not a general proposition. That was intended to be a fact-specific proposition.
and I'll come on to this again in relation to resources, but one of the obvious reasons for that is that it's resource intensive to supervise somebody who's been out on licence for a one-off offence, albeit a very serious offence of murder, to continue to supervise. It's going to be very expensive.
Well, one would hope that the protection of the public is not relaxed just because there aren't resources. I mean, that's not the point at all.
No, but the reason why I'm saying that is it's it's spending resources on somebody who objectively doesn't pose a real risk, and that's what's objectionable about it. Of course, if somebody's assessed it, that's why the discretion exists. It's not an automatic rule. You serve 4 years on your licence and then suspension is relaxed. It's a discretion that exists, and it's a discretion there, so that effectively money isn't wasted on somebody who isn't. In part, money isn't wasted on somebody who just doesn't justify supervision.
Well, here we've been looking at provisions for risk assessment by the parole board in relation to contingents of a licence. But as I understand it from what we saw earlier this morning in relation to Scotland, there's also a provision that says there must be risk assessment for everybody who's on the sex offender register. Is that right?
Well, I think we need to look up, find the provisions overlying. But my broad understanding of the way matter works is essentially consistent with what is described in the Professor Thomas article, which is that in principle there is a duty in relation to anybody who's in the sex offender register. But in reality, what happens, not surprisingly, is there is a distinction made, as one heard, between level 1, 2, and 3. At level 3, it's somebody who's posing a high risk and who is needing intensive management, and whereas at level 1, essentially a decision is made that this is somebody who can to a large extent be allowed to go on their
That
life.
is a risk assessment.
It is a risk assessment, absolutely, and it demonstrates again the sensitivity. I mean, everywhere one looks, I mean, the appendix, the first appendix to our statement of case was a letter, and you may have the court may well have seen this. It was written by the Treasury solicitor to the Court of Appeal in response to a request from the Court of Appeal, and it summarised a whole range of regimes of sort of civil orders that are imposed on. Go to it. It's our case, and it's Appendix 1. I think we in our case actually note that there is, I think, one provision that's missing from this that we've spotted. But the striking thing and the point we make about it is that there is no other scheme that is both indefinite and doesn't have a right of review. And in fact, there are in all sorts of contexts rights of review and rights to apply and to vary and discharge, which demonstrate how courts are able to conduct the sort of exercise we say is required by proportionality.
Well, one of the things that's missing from this list is the Mental Health Act provision.
Yes.
Both restriction orders and hospital orders, restriction orders, and hybrid orders.
Yes.
All of which are subject to review.
Yes. That wasn't the missing thing, but spotted that example, but that wasn't the one that.
It's not. No, it isn't the one that you
Because
spotted.
your request was convicted people, wasn't it?
Yeah.
You're convicted. It was. I'm just looking at the second line on page 26.
Yes.
The request was relating to convicted defendants.
Well, these are the orders I'm referring to.
Oh, they are.
Are on
right.
conviction.
Oh, they're people who've not been. They've actually stood trial and.
They've stood.
Yes.
Let us, if one's being absolutely precise, they haven't always
That's
stood
right.
trial, but they have been accused,
Yes.
and they have either been convicted or found to have done the thing alleged, or in certain circumstances there is a very limited power to impose a hospital order without on an offender, on an alleged offender, without having actually put them on trial. But basically, they've been put on trial.
And so one sees, and this was a matter I was going to come on to later, but I think felt now, that in all sorts of contexts, there are review mechanisms that are sensitive to the particular circumstances. I mean, most of them involve, in some respects, balancing. I mean, obviously, if one's looking at liberty, one perhaps needs a greater justification for restrictions than one does in other contexts. But it's clear the courts are able to balance individual circumstances against the risks they pose. And that fits in, as I say, into the basic concept that underlies proportionality, the need to strike a balance in an individual case, the need to determine whether the interests of the individual are outweighed by the interests of society. And the existence of a review mechanism as being important in that context is, of course, consistent with a line of authority that is now well established in the European Court about about the need for procedural safeguards in the context of Article 8. And one sees that, just to take Lordship and Ladyship to one case, yes, which was Buckley in the United Kingdom, which is at Bundle 5. Article 45. Page 76, paragraph 76. Second paragraph was really within paragraph 76. No discretion capable of interfering with the enjoyment of conventional rights, such as the one issue in the present case, is conferred on national authorities. The procedural safeguard to the individual will be respect to material in determining whether the respondent state has, when fixing regulatory framework, remained within its margin of appreciation. Indeed, it is settled case law that whilst Article 8 contains no explicit procedural requirements, the decision-making leading to measures must be followed, such as to afford due respect to the interests safeguarded by Article 8. And what one had, to compare the French system with the United Kingdom system, the French system, one has procedural safeguards because one has the right to apply to a court, so one can say this is no longer necessary in the circumstances of my case. In the English system, there are no such safeguards. Whatever the situation of the second response.
Well, there's no discretion.
There's no discretion.
There's no decision-making process.
No. Yes. Yeah. And one sees that from the Court of Appeal decision. And in the first respondent's case. So, in some respects, one can say, going back to Bouchercourt builds on S and Martha. S and Martha builds on Buckley in the United Kingdom, the importance attached to procedural safeguards. Now, the Scottish Government, in its case in particular, has cited cases where rigid rules have been upheld and held to be proportionate. But none of them concern the automatic retention of data. And ultimately, when looking at things like rigid rules, one needs to look at context. And one factor in our solution is particularly significant is the fact that one, in this context, has a much wider range of potential circumstances. One, as I've already indicated, has the one end of the spectrum, the serial POP department. The other end of the equation, somebody who hasn't offended for many, many years. And so it's unlike, for example, to use the example cited by the Scottish Government, the animal behaviour case, where one can see, in that case, all political groups that want to advertise are likely to suffer the same difficulties if they don't have access to TV advertising. Whereas here, one sees a very varied spectrum of potential cases, some of which there will be clear justification for what happens, in others there won't. So far, when looking at proportionality, and I'm going to come back to this in a moment, but I've made submissions that will apply equally to the second respondent and apply in all cases. But we do submit at this stage that it is important in the context of proportionality to recognise that the position of children is different. And that's because, consistent with, say, S and Martha, one needs to take account of context. And in S and Martha, it's quite clear, for example, the European Court took account of the youth of young applicants, reached the same conclusion in relation to the adult, but only took account of the youth of the applicants. We, in our statement of case, have set out some, in an appendix 2, I think it was, a number of authorities in various jurisdictions dealing with specific children. I'm not going to relationships in relationship to all of them, because one, I don't think there's any dispute about the principles on the rights, and secondly, because in some ways the principles have been helpfully summarised in most recent authorities, the Centre for Child Law Authority of the Constitutional Court of South Africa. It's claimed that that authority builds on earlier authorities. It's also perhaps particularly important because although it was applying, considering the situation under the South African Bill of Rights, it expressly noted that in that context, the Bill of Rights was intended to reflect the obligations of South Africa under the United Nations Convention. So perhaps identifies matters that are relevant in that context, and obviously the United Nations Convention is relevant to population.
For myself, it seems to me the relevance of children is essentially a factor of risk assessment. We're, in this case, looking at the consequences of not being able to review a requirement to register one's address. And that is going to be biting after any child has become an adult. And therefore, one's not looking at what's the appropriate sanction to impose upon a child, anything like that. One's asking the question, do the same presumptions in relation to the risk of behaviour continuing apply in the case of a child as in an adult?
It's not purely that, and one of the reasons why I say it's not purely that is this. One of the things that is clear from the UN Convention, as emphasised in the Centre for Child Law, is that, of course, in relation to children, there is always a need to require the welfare of the child, and a particular need also to consider rehabilitation.
Yes.
Now, that, in general, is inconsistent with having a rigid regime for children. Because if one is looking at the balance, the need for rehabilitation, the need for particular assistance, essentially, to be given to the child to resume their role in society, may be a particular factor that needs to be taken into account on the facts of a particular case. And one sees, some of the evidence in the case, and we may come to this again, some of the evidence both from the Howard League and from the respondent himself talks about, for example, the impact on a child of being faced with the knowledge that for the rest of their life, whatever they do, they're going to be subject to these registration provisions. And of course, when one looks at, for example, the topic one was talking about earlier this morning about risk of disclosure, if one looks at, for example, the travel restrictions, an adult is likely to know how significant they are to them. They're likely to know that they have a job that never involves them travelling. They go on holiday once a year. It's not necessarily as great an experience. Whereas a child who goes through that process of planning their career, looking at where they want to be in 10 years' time, has the knowledge hanging over them that for the rest of their life, as they try and develop their career, these restrictions are going to be in place and that they may limit their access. And to use perhaps maybe I hope this isn't a silly example, but an example of the way children think. I mean, we all know children who want to be airline pilots. It's a glamorous job. If you're 11 and you're convicted of this sort of offence, being an airline pilot is probably ruled out because you can't travel at short notice. You have to give your travel plans. Your airline is going to be almost inevitably aware of your conviction.
At what age do you cease to be a child for this purpose?
Well, that's a point that's dealt with, we say, in the Smith case, and the critical point in our submission is that when you look at offences committed by children, they remain offences committed by children, despite the fact they become adults. And one reason for that, and this is said in Smith, and we can come to Smith after lunch, I'm conscious of the time, but one of the reasons for that is because, in part, when you look at one of the reasons why children are treated differently, as my Lord Phillips said, is because children mature. And so it's perhaps easier to say, well, this is somebody who's changed than somebody who's an adult.
That suggests that the review, actually, which you're asking for, will take place when the child has matured.
Well,
so that initially, when the 12-year-old is planning his or her career, the spectre is going to remain over them. There will be an uncertainty as to the future. Well, that's bound to be the case, isn't it?
Well, yes, but at least the point that the children make, that's made in evidence regarding the children, is that they know the child who's 12, who wants to be an airline pilot, knows that whatever they do, they can't address the fact of registration. If a child is 12 and knows, if I comply with supervision, if I do what I'm asked to do by the probation officer, if I make sure that I attend whatever courses are on offer, so that I demonstrate that I've taken on board my offender and sought to mature, then I will be able to get rid of this stigma that attaches to me. Then I'll be able to potentially do the job that I want to do. One can see that that has an impact on the child's thinking when they're 12. And that's why the review mechanism, it matters from the child's point of view, whether the child is in a different position, even if the review mechanism won't actually take effect until they're an adult. It's that knowledge when they're a child that they will have an opportunity to change their position that matters.
Does the Rehabilitation of Offenders Act mean that they don't need to, their conviction wouldn't be known about? Is that right?
Well, in the odd position of the first respondent, actually, yes, because one of the oddities about the regime is, although my learned friend says, well, they match, they don't actually completely match, in that the Rehabilitation of Offenders Act applies to over 30 months. And so that in the particular circumstances of the first respondent, actually, the Rehabilitation of Offenders Act wouldn't actually require him to disclose his conviction for the rest of his life. But the more general point is that the difference between the Rehabilitation of Offenders Act is that if one applies for a job and one has a conviction years and years ago, and the application form goes in, it's treated in confidence. It probably goes to a human resources team who know what they do, who are conscious of the need to treat these things as sensitive and the probable irrelevance of a conviction many years ago. If it goes to, if one has these sorts of restrictions, as one does in this case, on travel, one doesn't merely put in an application form at the start of employment and then it hopefully gets securely filed, etc. One is constantly subject to the potential risk that one has to say, I can't travel tomorrow, I can't travel today for work, because if I do, I'm committing a criminal offence, and which generates the immediate question, well, why is it going to cause a criminal offence? Why are you going to be guilty of a criminal offence if you travel? And
I think you're really saying you can't really be fully reintegrated into society after rehabilitation while these restrictions remain because of the impediments they impose.
Absolutely. Absolutely. And rehabilitation is another particular feature that's been identified as being particularly important in the context of children.
Yeah.
By my watch, I think it may be...
Got a few more minutes.
Thank you. So my watch is... we've talked a little bit about children. I would invite... I'm quite happy to take the court to the relevant passages, but I would invite the court to look at the Centre for Child Law. I accept it's in a very, very different context. It's about mandatory sentences for children. And of course, I accept that, as the European Court has made clear, this is not about punishment.
Could you give the reference to it?
Sorry, yes. It's volume 10, tab 106. Okay. Sorry. But the statements of principle are clearly intended to be statements of principle and are, in my submission, important indications of the particular factors that arise in the context of a child. And I'd particularly ask the court to look at paragraphs 27, where it's noted that children are less mature, more vulnerable to influence, more capable of rehabilitation, the point that Lord Phillips made. 28, which indicates that because children may stem from children's crimes rather may stem from immature judgment, full moral accountability may be too high. That may be some significance, because my learned friend was saying effectively yesterday at one stage, I think, that one of the reasons why this scheme might be justifiable is because effectively somebody has acted in a way that's brought these responsibilities upon themselves. Well, an adult's actions in bringing these responsibilities upon them may be easier or it may be easier rather to say that an adult should be held responsible for their actions than a child. Paragraph 37, emphasising the need for hope and the possibility of, emphasising that children embody society's hope and its investment in the future. And that's important because it demonstrates again the need to rehabilitate children. Paragraph 47, citing...
There's a limit to how far you can take this point. I mean, all this applies to you if you're 20, as it does if you're 18 or 17. I mean, the rehabilitation is a critical feature of the system where we are. Well, and I take your point that there are particular concerns about children.
No, I mean, and I also take my Lord's point that it always seems a little harsh that there is this distinction drawn between the 19-year-old and the 17-year-old. But children are regarded as special because, and one has to draw a line somewhere. But clearly, the first respondent is well well within that line, and 18 isn't necessarily the age that every state adopts as being significant when treating children differently, but I don't think it is plainly significant in the facts of this case.
Now we will adjourn. Will you have a word with Mr. Owen and make sure that you don't encroach too much on the time?
I think I can be quite short, 15 to 20 minutes.